Catholic University of America, Washington, D.C. In 2009, he was a visiting professor to Queen's University, Kingston, Canada, to handle a course on comparative legal traditions. He was recipient of Shastri Visiting Research Fellowship in 1992 in research on comparative study of language rights in India and Canada in the universities of York, Toronto, and Ottawa. His publications include 4 authored books, 3 edited works, and 85 research articles in legal journals of international and national repute. There is hardly a scholar in India today who would not have referred to Professor Bhatt's work at any point of time. During his illustrious career, he has been closely associated with the state and central government on numerous research projects on a variety of subjects, including constitutional multiculturalism, language rights, multiculturalism in international humanitarian law, law on third sector organization or NPO organizations, space law, etc. We are very grateful to you, sir, that you have agreed to take time out and address our participants. We have students from different law schools all over India. It's a pan-Indian as well as a pan-SARC representation, with our friends from Nepal also showing interest in our program. The students have been here with us for 5 days now. They've been very enthusiastic and they are eager to listen to you. We request you to address the gathering. So from wherever, if you're comfortable there.
Thank you, Professor Vasantan Mishakavi. Dear participants in this week-long seminar on comparative constitutional law, it gives me great pleasure in presenting some about constitutionalism's impact on constituent power. Constitutionalism as a source and a limitation of a constituent power in South Asian constitutions. That is the title of the presentation. When constitutions are taken for a comparative study, usually it is the Western model, American Constitution or Canadian or other constitutions are referred for comparison. But it is quite appropriate to study or neighboring constitutions along with the Indian Constitution. There are similarities, there are differences, there are common historical traditions, there are common social problems, common economic problems, and there are differences also, because of their strong commitment to constitutional democracy might be doing well, the democracies might be flourishing, whereas in some other systems, because of affiliation to certain ideologies or a deviation from some of the essential morals of a constitutionalism, there may be some injury to the very constitutional functioning itself. That's the experience that we find in relation to all these South Asian countries is such that we get a mixed picture about the application of a constitutionalism. What is a constitutionalism? Constitutionalism is a philosophy that believes in a supremacy of the constitution. It is with some cogent reasons that politically, socially, ideologically, and economically, it is more appropriate to abide by the constitution that a philosophy of a constitutionalism is built. ever since the time of Aristotle, there was emphasis on constitutionalism, and it was regarded by him that to act in accordance with the Constitution is a veritable path of salvation. It is not a path of slavery at all. Thus, the way in which the human conduct in the public life should be ordered to the mandates or imperatives of the Constitution. About that, we come across adequate philosophical input from the concept of constitutionalism. Constitutionalism is a gathering support from history, tradition, morality, and a nation's aspiration for a better future or a good life. It has a support of the tradition, and it has such a kind of a foresight about the future and a commitment about the way in which the whole society could be taken in the path of the goals that are enshrined in the Constitution. Constitutionalism is a trust that the people repose on a set of principles which keep the government in order. Let the government be kept in order, or there shall be such kind of limitations within which the government shall work. That was the viewpoint of Carl J. Friedrich, who elaborately wrote on constitutionalism. When power is purposive, keeping the power totally uncontrolled will have the consequence of anarchy. And keeping a power under full control will be resulting in another extreme, where the social expectation about the benevolent way in which a power would be exercised will not be performed. That is why between these two a balance is to be struck according to Carl J. Friedrich. Binding force of the Constitution arises from a socio-cultural acceptance or understanding of the right reason by the community. It is said by Cicero that right reason is the very basis of law. And constitutionalism tries to build up a philosophy based on reason. And it is only with that kind of community's understanding about the reasons for supremacy of the Constitution, or the advantages of following the Constitution because of its ideological commitment to the cause of socio-economic justice, human rights, welfare, governance, rule of law, and so many paramount principles. Because of that factor, that people accept that constitutional system as a superior norm of a higher obligation. Internally, constitutionalism contemplates that there will be adequate mechanism through which strict compliance with the Constitution will be possible. Power of judicial review, rule of law, separation of powers, federalism, and various other new mechanisms could be put into application to ensure that the holders of powers under the Constitution will act only in accordance with the Constitution. This is the internal aspect of constitutionalism, or inner aspect of constitutionalism. Externally, constitutionalism gathers support from history, from a tradition, from the times of Magna Carta, how overarching of various rights and principles of good governance has ultimately resulted in a better situation, better governance. Or it gathers support from principles of morality. See, in essence, constitutionalism gives effect to principles of morality. See, it's a consideration about human rights, or it's a respect for human rights, or it's a concern for good governance, or it's a expectation that national unity will be maintained through the application of a constitution. All this are supporting the idea of supremacy of the constitution. Further, if you look to the constitution, it will be quite clear that it has a strong impact of culture of that country. See, writing about the South Asian, Asian constitutions, some scholars who have written about the Chinese constitution or constitution of Thailand, Indonesia, etc., point out that constitution is also product of culture itself. Professor P.K. Tripathi views that the constitution has such a close nexus with the culture of the country. Whether we really gave effect to the culture of the country in the making of the constitution, that is a debatable question. If you look to the very high tradition of constitution and constitutionalism as developed in ancient India, it is quite visible that they had such a perception that by entering into the organized political community, the people are actually respecting such a system where compliance with the good law will be ensured in economic actions, human desires, or public actions. That Trivarga principle, that human desires as well as economic actions and property relations shall conform to good law, dharma. That is one of the strong basis for constitutionalism as developed in the ancient system. How the ruler shall act, what is his responsibilities to bring welfare. It is in the welfare of the people that the state's welfare or the good of the king lies. Or various other notions about the policies relating to directive principles or fundamental duties can be found in the ancient Indian jurisprudence. Warner Minsky points out that by incorporation of Part 4A of the Constitution, for the first time an effort is made to revive that strong cultural tradition which India has about the participative community, where it is through the performance of duties that various rights get better protected, or various powers will be exercised for better ends. Of course, even at the time of the making of the Constitution, the Constituent Assembly debates reflect the views of constitution makers who elaborately refer to the Indian tradition. For example, when relating to property right, there was an elaborated discussion. What was the contemplation of ancient Indian thinkers about property? There was that discussion. Or when the concept of secularism was to be incorporated in the context of religious freedom, again there was a reference to Sarva Dharma Samabhava and various other principles. Of course, relating to right to property, there is an extensive discussion about the way in which the Indian idea of economic justice is explicit in so many of such Shastra writings, etc., and how it is to be incorporated. See, that culture of the country molding the contours of the constitution is something natural, something logical, and it's quite appropriate also. Because the constitution will grow on those lines. That will be the effect. How exactly a constitution is made? My theme is that it is from the general understanding of the philosophy of public life, or it is the ideology of constitutionalism that gives rise to the making of the constitution. About the making of the constitution, John Rawls refers to the four-stage approach. First, the constitution is born in the minds of people. See, people consider that the constitutional principles of a certain sorts are to be regarded as something to be incorporated. If you look to the process of making of Indian constitution, it is implicit that it is not only the constitution makers, even the common masses were also aware, or they were expecting that the future system of governance will be such that there will be a mechanism through which their welfare would be possible. In a Traced with the Destiny speech by Jawaharlal Nehru, it is possible to infer that wiping out every tear from every eye is the approach of the makers of the constitution. Because during the colonial period, when people suffered immensely, and illiteracy, poverty, ill health, and so many other factors had impeded the growth of the society. It is only by such a welfare state of policy that a constitution is to be framed, and thus that people's understanding about the ideals of the constitution was the basis through which the constitution makers made the constitution. When it is first born in the minds of the community as such, then it is the people's representatives who will take that message to the constitutional hall, and then they will give proper shape to it, formulate it in a proper form, and subsequently they will refine it, and the judiciary, then of course subsequently again the legislative body may supplement some of the gaps or some of the inadequacies in the constitution, and that is how constitution becomes a full-fledged system. Then finally it is the judiciary which gives a meaning to the constitutional provisions. This is how a constitution is going to be enacted. See, if you look to the experience of South Asian countries, there's India, Pakistan, Nepal, Bhutan, Bangladesh, Sri Lanka, it is clear that most of these countries at the time of making of the constitution were they were freeing themselves from the rule of colonial masters. The process of decolonization had demanded such a active role on the part of the state to create such an atmosphere so that they can better serve the interests of people. Further, these nations have some common features, that there are multiple languages, there are multiple religions, multiple ethnic communities, and multiple regions. Because of multiplicity of several factors of diversity, it is necessary to establish some amount of proper balancing amidst these communities, so that ultimately social harmony is to be made possible. Thus, poverty is to be eradicated, then a diversity problem is to be properly dealt, and the democratic framework with the human rights values should be made quite vibrant. These are all the responsibilities on the part of these countries which are moving away from a colonial world to the period of independence. For a revival of their past glory, or for succeeding in the new atmosphere where they are to compete or they are to overcome various types of difficulties, it is essential that the constitutional structure should be providing for a very effective governance system, and it should enable the building of the nation with an inclusive policy. Inclusive society is something contemplated. Now suppose so the sections of the society are left out or marginalized, maybe scheduled castes, maybe scheduled tribes, or even women also, or various other sections of the society. See, how to bring them to the mainstream and provide that position of equal respect and equal rights. About that the constitution makers should think. Thus, the problems that were faced by almost all the countries which made their respective constitutions in a 20th century and even in the 21st century in South Asia had these types of problems. See, although the problems were similar, the responses by these nations to those problems were not similar. The constitution makers have different approaches. For example, some constitutions are based on ideologies. Some constitutions are based on a philosophy of constitutionalism, and some are influenced partly by constitutionalism and partly by these ideologies. See, if you look to the constitution of Pakistan or constitution of Bangladesh, we come across a reference to supremacy of the will of God, or of course invocation of that Islamic principles can be found, or it is made in the name of Allah, or various other references can be found. But they are not theocratical constitutions. Although such references are there, and there might be even a declaration of some principle that Islam is the official religion of that system. Still, the way in which other provisions of the Constitution are framed and they are put into application do not suggest that there are theocratical measures. On the other hand, principle of secularism, there is emphasized in other constitutions, like a Constitution of India, or Constitution of Sri Lanka, or say Constitution of Nepal. There is a 2015 Constitution. Those are provided for a different position. See, what I intend to emphasize is that the approaches of these 4 or 5 countries relating to constitutionalism are different, because they are partly based on that ideology of constitutionalism, and partly based on such a ideology like a commitment to some religion, etc. But commitment to some religion, for example, in the Constitution of Bhutan, there we come across a reference to one principle that Buddhism is the religion of the state. But that does not mean that it is a non-secular state. It's a recognition of Buddhism as a special religion of that state is because of the special situation. In the same way, in Sri Lanka also there is a recognition of Buddhism as a religion of Sri Lanka. Because of some cultural traits, cultural principles, such a recognition might be there. Even in even in constitutions of Pakistan or Bangladesh, there are such references. See, about the impact of constitutionalism upon a constituent power when we are to discuss. How exactly the making of a constitution as well as molding of the constitutional principles. In this context, constitutionalism has influenced. About that we have to think. Here we have to first know what is meant by constituent power. See, constituent power is the power of making of the constitution. It is a sovereign power. It is a people's power, and it is a power that brings the constitution into existence. That which gives rise to constitutional norm is to be regarded as a constituent power. See, if that notion is clear, perhaps there would not have been confusion about the distinction between a constituent power and legislative power. Legislative power is a power recognized under the Constitution. It is not synonymous with the constituent power. But in India, in a I.C. Golaknath case, there was some approach that power to amend the Constitution is also a legislative power that is to be dealt under Article 13 of the Constitution. See, either in a Shankari Prasad case or even in a I.C. Golaknath case, about the need to control constituent power, there were certain thoughts, there were certain arguments. In Article 368 of the Constitution, because of the 24th Constitutional Amendment, we come across now a clear provision that in exercise of constituent power, the Parliament may amend any provision of the Constitution. This power to amend the Constitution is also a constituent power. That is clearly stated. See, how exactly constitutionalism is a source of a constituent power? About that, when we think, it is possible to find an answer in the designing of the constitutions in these countries. Vast literature on constitutional design would use an idea that constitutionalism as a philosophy or a theory or concept gives guidelines in the making of and institutionalization of a constitution. See, if a constitutionalism has that ideology of say human rights, welfare, limited government, rule of law, welfare, multicultural society, harmony and welfare and all those things, those goals or those ideologies are to be incorporated in a specific manner in the Constitution. So the process of making Constitution is actually a process of embodying constitutionalism into the Constitution. The larger philosophy of the Constitution is going to be incorporated into specific provision of the Constitution. This process is an exercise of a constituent power. This constituent power is the means through which constitutionalism is getting into the Constitution. And this process should be a democratic process, because if a constitution is laid down by a dictator or by few chosen members of the royal authority, it is not possible to expect that they will really reflect the people's aspiration or those ideologies. When the King Tribhuvan in Nepal constituted a small committee of say 3 members to constitute to draft a constitution. Or when King Mahendra constituted a drafting committee of just 12 members who were actually hand-picked persons. Actually, those efforts would not result in a appropriate formulation of constitutional principles. On the other hand, when a Constituent Assembly is formed, either through general election or on the basis of general acceptance by the society. Of course, Indian Constituent Assembly in India was based on a election. Already existing members of the legislature were to act as members of the Constituent Assembly. And some of the members were nominated from various provinces or states. This is how Constituent Assembly was created. See, regarding formation of a Constituent Assembly, Gandhiji had one bitter remark. How is it that this cabinet mission is authorizing the making of a constitution? Can we call that body as a sovereign body? If the entity is not something from within, or it is not a sovereign, but it is some entity suggested by a foreign agency, how can we call it as a sovereign? That speaks about the desirability of having representatives in an independent country to form the constitution. But about the legitimacy on the part of this Constituent Assembly, there is much discussion in books like Granville Austin's Constitution, Cornerstone of a Nation, and other books. It is possible to say that people's acquiescence of making of the Constitution and people's participation in the constitutional process or in a general election and simply accepting the implementation of the Constitution, that is a sanction behind the Constitution. That itself is speaking about the legitimacy. Of course, that could be regarded as a very satisfactory explanation, but it is not a very appropriate method of making of the Constitution. See, in Nepal, while making the 2015 Constitution, when there was an interim Constitution of 2007, and a whole process of making of the Constitution was going on, the first Constituent Assembly was not in a position to decide on a proper lines, because it was not a elected body. See, I mean, it was not a fully elected body. There are about 600 members. Only 240 or so were elected members, and some more members were opted as experts or as persons who could be recognized as members because of the recommendations made by various political parties. Thus, it was more a kind of arrangement made amidst the political parties. Once a Constituent Assembly has that kind of character, then it is quite possible that their partisan interests or their internal conflicts or their own personal considerations or political ego or various other factors might be operating. That is why the first Constituent Assembly during the interim government period was not successful in bringing a draft of the Constitution. Or even some of the drafts prepared were not acceptable. Then, of course, there was an election. And in that election, because of the people's distrust or dissatisfaction about some of the political parties, or people's emphasis on some of the economic, cultural and regional considerations, that there should be a federal form of government, not unitary, or there shall be adequate representation, or such considerations, that brought out a new composition of a Constituent Assembly, because of which making of the Constitution was becoming an easy task, and yes, within a span of 1 year they could finalize the draft, and they could even promulgate the Constitution. See, that's the constituent power needs to be exercised by such kind of a body which is democratic in its functioning. Suppose Musharraf or Ershad or Yahya Khan or some other person, I mean some other political leader, or say martial law administrator, amends the Constitution according to his whims and fancies, and subverts the provisions of the Constitution, or puts an end to independence of a judiciary, or makes the rule of law non-workable, etc., then we find that the constituent power is not exercised by a democratic body. Thus, in order to effectuate a constitutionalism, the constituent power is to be exercised in a democratic process. That speaks about the relation between constitutionalism and democracy. What is the exact relation? The relation is that of mutual support and mutual balancing also, and it is not possible to say that constitutionalism can flourish in the absence of democracy, or democracy can flourish in the absence of constitutionalism. Both have to go together. Thus, constituent power is to be exercised in such a way. This constituent power is either a fully fledged power of making the original Constitution, or it might be derivative power of making some marginal changes to the Constitution, or bringing amendments to the Constitution. See, by way of addition, alteration, repeal, substitution, any amendment can be brought to the Constitution. These are the words used in various provisions relating to constitutional amendment. But the term amendment does not suggest that there could be repeal. Consequential repeal of a specific provision might be the outcome of making of a constitutional amendment. But that does not mean that it repeals the Constitution as a whole. Thus, even after the amendment, the Constitution shall stand with the same identity, or it should continue with the same commitment to those ideologies with which it was born. Thus, all those basic features, basic structures, or those ideologies, like a limited government, guarantee of human rights, or judicial review, federalism, separation of powers, rule of law, multicultural system, etc. All these things should be continuing along with the amendment. This is the consequence of constitutionalism upon a constituent power. See, how exactly that is done in the Indian context, let me briefly point out. Since you are aware about the Indian scenario, I will not be going threadbare. See, according to Fali Nariman, a constitution is a product of rule of law, and a rule of law is a product of institutional morality. That is why there is that kind of a continued nexus between a morality and the constitution. See, any law should reflect the essential moral principles. About that there is no doubt. But constitution, being the supreme law of the nation, goes a step ahead because it has to gather the basic moral principles of those institutions. Of course, in the making of the constitution, how constitutionalism had that kind of impact. About that, the historical factors can be considered. Of course, the British given constitutions were not satisfying the Indian people on the basis of that negotiation between the colonial masters and colonial subjects. Although some petty concessions were provided, or they were given from time to time, or they were expanded from one legislation to another legislation. Those were not actually satisfying the aspirations of the people. See, Government of India Act of 1919, 1935, or even earlier legislations, they provide for some mechanism of a government. And of course, from one legislation to another legislation, there might be some marginal improvement, but that will not be satisfying the Indian people. As an alternative to that, people evolved indigenous constitutional models. What is the first indigenous constitutional effort? Any idea? First indigenous constitution made by the Indians, not something framed by the British. Yes. See, the literature on constitutional history provides information about the way in which British constitutions, British given constitutions had created some kind of principles in favor of say self-rule, federalism, or limited government, rule of law, and some space for either secularism or protection of a property right, and some stray reference to equality, so that on the basis of race there could not be any discrimination. But some Indian effort was made, some indigenous effort was made to have a full-fledged constitution, which was the first attempt. Yes. Have you any idea about a Tilak bill, Balangar Tilak bill, the 1895 bill? That is regarded as the first indigenous effort of framing the Indian Constitution. Of course, Balangar Tilak had so much of emphasis on liberty. Freedom is my birthright. About various rights to be protected in the Constitution, or a democratic system that is to be developed. All such measures were laid down in that 1895 bill. Of course, it was not drafted by Balangar Tilak, but it is attributed to his thoughts, and it is on the basis of his inspiration or his guidance that 1895 bill was drafted. That is one understanding about the 1895 bill. Subsequently, there were some other efforts. Have any other idea? Perhaps now you may be getting a clue. What were the subsequent efforts? Because we did not just develop the Constitution on the basis of the Government of India Act of 1935. Yes. Gandhi Anniversary Bill of 1925 also, 1925. That was the second effort. And the next effort is what? Exactly. Motilal Nehru Committee Report, 1929. See, those constitutional values are, they were being developed through such a people's understanding, through the indigenous efforts. It is not something given by the British, or it is not something just discussed and dealt at the context of making of the Constitution by the Constituent Assembly members. Even prior to that, all these preparatory measures were there. Apart from that, yearly resolutions were made by Congress, especially Karachi session, Lahore session, and various other sessions where Congress had evolved certain policies. This had their own impact. Then about the protection of interests of farmers, or need to have agrarian reforms, or need to have protection of tribal communities, or bringing various welfare measures for protecting women, especially by changing the provisions of family law, etc. About this, some consensus was built up. Thus, constituent power that is exercised by the Constituent Assembly had gathered that kind of a consensus. There is that support of a consensus, and it is not just a one-time action on the part of a Constituent Assembly. See, from generations, people had that kind of awareness, or they had that concern for these values. That is how constituent power was influenced by constitutionalism. Because from the times of 1895 to 1950, how much of Indian thoughts had influenced the making of the Constitution? This would dispel the criticism that Indian Constitution is only a piece of eclectic measure derived from borrowing from other systems. In fact, universalism is an approach on the part of the Indian Constitution makers, and even the judges who implement the Constitution. They have that kind of approach. Let noble thoughts come from all sides, whether it is the English Constitution, or American, Canadian, or Australian Constitution, or any other constitution. if good thoughts are forthcoming, yes, let us be open-minded to that. Even today, Indian Supreme Court or Indian legal system has that kind of approach. See, Constitution is essentially not something to be straight-jacketed within the territory of a particular state. Because the constitutional ideas or ideologies are having a necessary propensity of migrating or moving to some other systems. When we live in the era of migration of ideas, having open-mindedness to absorb those ideas or respond to those ideas could be regarded as quite appropriate. That is why Indian Constitution grew with all strength by gathering support from various philosophies and ideologies which are suitable to the Indian constitutional structure. If it is not something suitable to Indian constitutional structure, they will simply reject. But if it is suitable, then they will revive those ideas. If you look to the way in which locus standi was liberalized, or the way in which basic structure ideology was put forward, we find that there is that kind of support gathered from the constitutional ideology, support from a history, support from the political, sociological thinking, etc. We should look to the interdisciplinary aspects of basic structure. It has the dimension of economic advantage of bringing some kind of federal relation where the economic unity or common market will be strengthening the whole system, or there might be sociological reason behind the basic structure principle. The acceptance of that constitution, I mean acceptance of that feature of the constitution as essential is something dominant in the minds of the people. The reason is that it is through such a measure that the good of the society could be achieved. Of course, cultural dimension can also be there. Of course, any legal concept for that matter, it is having certain dimension of social, economic, cultural and psychological nature. That is why basic structure concept is to be examined from that perspective, because it is a growing concept. It is becoming a epiphenomenal, because it is not confined to just examining whether particular constitutional amendment is in accordance with the basic feature or not. It is going beyond that. See, sometimes even administrative power may be tested, or exercise of some other power may be tested with the touchstone of a basic structure, or interpretation of the constitution might be done in the light of a basic feature. See, one thing that we have to remember about Indian constitution is that constitution makers, although developed the bare constitutional structure, left so many interstices to be filled up in course of time. In other words, incrementalism is something recognized in the growth of Indian constitution. Relating to languages, they said that this is a matter to be decided after 1965. Until 1965, yes, English shall also continue as one of the languages. But about equal status of all languages and a recognition of regional languages in their respective domains, the constitution makers had agreed. Then about say formation of states, the constitution makers did not lay down any straitjacket formula. They left it to the discretion of the parliament, and the parliament decided in accordance with the maturity of the demand or desirability and various other factors. That is how from 14 states to 29 states there is that kind of development. And incrementalism is something recognized. Once again, it is keeping certain amount of flexibility so that between constitutionalism and a constituent power, there could be that kind of a nexus which the factor of time will build. Time is one of the dependable factor, because it has that potentiality of curing or say slowing down or providing appropriate answer. So the factor of time is to decide so many things, even relating to directive principles of state policy. Constitutionalism had this approach that although these are to be left as policies, in what circumstances these policies may be elevated to the status of principles, that should be left to the discretion of the state. Let the state decide. Because in accordance with the economic development and competence of the state, that these policies are to be given effect. It may be relating to right to work or right to health or various other rights that are recognized or referred in Part 4 of the Constitution. The way in which the gap between principles and policies has been dealt by the judiciary points out that, again, constitutionalism is given a greater role in influencing the constituent power. See, if a constituent power is a means that it's a power of making the constitutional norms, even a judicial interpretation is also, there is a power of interpreting the constitution, should also be considered as possessing that constituent power, because it brings a new constitutional norm. Now suppose right to life was interpreted merely as continuation of human existence, very cold way of putting things, in a very logical manner it is said in a Ekagopalan case or in those types of judgments. But when after Maneka or Francis Corali Mullin and other cases, there is an approach that right to life means a right to live with the human dignity, and all those components which make life livable with the human dignity should be considered as aspects of right to life. Then there is a different interpretation, a different approach, or different meaning to the term right to life. See, this change which was brought through exercise of power of judicial interpretation has changed the meaning of the Constitution. See, there is a view that constitutional amendment is possible through judicial interpretation also. If that is so, then is it also not a kind of a constituent power? And what is the guidance which the judiciary should get in the course of exercising that constituent power of amending, interpreting the constitutional provisions? Again, it is the reservoir of ideology in the form of constitutionalism from which it has to gather support. See, if we go for checking the, if we go for keyword search of the term constituent power. In so many judgments, there is a reference to constituent power, even in those instances where power under Article 226 is going to be exercised. See, any power that is conferred under the Constitution is regarded as a constituent power. That is actually not an appropriate interpretation of the term constituent power. Constituent power is the power of creating a constitutional norm, and that power may be under Article 368 of the Constitution, or it might be under Article 141 of the Constitution, where the Supreme Court's interpretation of the constitutional provision will be bringing a new constitutional norm. See, there's that kind of development can be found in the Indian constitutional system, and of course from Keshavananda case we come across a very elaborate and quite a distinct approach relating to constitutionalism as well as its impact on constituent power, because from Keshavananda onwards, when a basic structure theory is developed, every effort is made to ensure that constitutionalism will be operating in such a way that destruction of democratic principles upon which constitutionalism is based will be avoided. There is the observation that we find in I.R. Coelho versus State of Tamil Nadu. Of course, about the experience of other countries, especially neighboring countries, we have to look into. First, let me take you to the constitution of Bhutan. The reason of choosing such a preference is to point out how high moral principles of augmenting happiness amidst people in their day-to-day life is given a central stage in the 2015 Constitution. Yes. No, it's a Constitution enacted, I think, yes, enacted in 2008. Adoption of that Constitution took place in 2008. See, Bhutan is blessed by a tradition of very noble kings who had a very sincere commitment to the welfare of the people. In 20th century, we come across 5 very eminent royal authorities who provided that kind of leadership to establish a very good political, social and economic atmosphere in Bhutan. During the times of Ugain Wangchuk, between 1907 and 1926, national unity was emphasized, stability and tranquility could be attained, and people's welfare was the central focus of attention. That rule was succeeded by Jigme Wangchuk. The period is between 1926 to 1952. Here, efforts were made to modernize, to educate, to bring economic reforms. So, at the cultural level, the people were to be made human resources. Of course, thinking that human beings are wealth of the society, or their resources, and we have to augment those resources by infusing the input of education, input of skill, competence, etc., and even input of good thinking, so that amidst different communities there will be appropriate relation. That was a given emphasis. Then, of course, during those times, about the supremacy of royal authority, there were such practices that there was no need for any royal charter or constitution as such. Dorji Wangchuk ruled between 1953 and 1972. He is regarded as a father of modern Bhutan. Political reforms, constitutional monarchy, social reforms were introduced in an unprecedented manner. And Supreme Law of Bhutan was drafted. This included list of fundamental rights and various references to cultural rights and so many other things. His rule was followed by Singye Wangchuk's rule. It was between 1973 and 2006. Here we come across overall development of Bhutan and a very conscious effort to bring Bhutan to the constitutional governance. Social, economic, political and democratic reforms were undertaken. Welfare activities were given so much of emphasis that the king was regarded as a people's king. The replica of a philosopher king of Plato's time can be found in the form of Singye Wangchuk. And it was Singye Wangchuk who initiated the idea of framing a new constitution. Sonamanta Ogbay, the Chief Justice of Bhutan Supreme Court, was entrusted with the task of drafting the constitution. The process started in 2001, and if you look to the reading materials that there is provided, it is clear that what are the issues that are to be dealt in the making of the Bhutanese constitution. There was a discussion. Then what are the sources from which these values are to be gathered? The sources included 100 constitutions, then a whole of a Buddhist philosophy, then a history, morality, and so many other things. See, a constitution cannot grow just out of some parchment of a legal paper. We have to gather support from various sources so that a constitution is to be developed. Then it was submitted to expert review. Our eminent advocate, K.K. Venugopal, was one of the members in the expert committee. Then the draft constitution was circulated to the people. And people consulted those draft constitutions in social gatherings, in newspapers, or in various discussion and in various forums. See, even about Indian constitution also, the way in which people used to respond to the developments that were taking place in the Constituent Assembly, when the newspapers carried those information. There is speaking about people's indirect participation. People's participation was there. It is not something exclusively product of the task on the part of these members of the Constituent Assembly. Then the matter was referred to Parliament. Parliamentary debate took place almost 6 to 8 months. 3-4 sittings were there, and the constitution was adopted in 2008 July. See, in the preamble as well as other prominent provisions of the constitution, we come across one of the important goal of the Bhutanese constitution, that the constitutional functioning of the whole governance shall result in augmenting the happiness. Gross national happiness is a concept that is very elaborately or strongly propounded in the Bhutanese constitution. See, happiness is a beautiful word. It actually it's something close to the heart of every human being. And if happiness is there, then of course so many other things will be there. And happiness will be possible when there is a peace, a tranquility, and so many other things. And happiness will be possible with the good environment, good relations, good thinking, and so many good things. Thus, center staging the concept of happiness in the very functioning of the constitution is one of the achievements of the Bhutanese constitution. Bhutan is a small nation, but the high thinking with which it propounded for the first time the concept of happiness as one of the aim of the political system is something quite significant. Michael Kirby appreciates that approach of center staging happiness. Yes, that is about the impact of constitutionalism upon a constituent power in Bhutan. Of course, about power of amendment, there is a provision which says that by 2/3 majority of the members sitting and voting and 3/4 majority of the house as a whole, there can be amendment. And in case the Gyalpo or the king considers that any amendment is something used to be reconsidered, or suppose there is a need for referring to the people, then a referendum can be conducted. So in such checks and balances can be found. See, it is providing for a constitutional monarchy, and the king has to retire after attaining the age of 65. Then he is also subject to impeachment or other proceedings, and how king shall also be subject to rule of law. About that we come across such a development. The constitution of Nepal also reflects that close nexus between constitutionalism and constituent power. The making of it has that kind of lesson to teach. From 1948 to 2015, almost for a period of 6 decades, Nepal had as many as 7 constitutions. The 1948 constitution was a Government of Nepal Act, which was promulgated by Rana Maharaja Padma Shamsher. Of course, that was a document only recognizing the supreme position of the king, no principle about accountability or sharing of powers or people's participation, etc. Nothing was there. But a framework of legal principle could be found, and that was followed by some revolution in 1951, and King Tribhuvan came to power in 1951. See, he did not learn the lesson from the revolution or people's movement. He compromised with the earlier promise that he had made by not fulfilling. The 1951 interim constitution was sidelined, and a Constituent Assembly was not convened, and it was regarded as totally unnecessary. Interim Government of Nepal Act was passed in 1951. For a period of 11 months, it was in work, it was in application. Then, of course, no, yes, Constitution of a Kingdom of Nepal was enacted in 1959. King Mahendra succeeded in 1958, and Constitution Drafting Committee was constituted by him. Of course, from 1962 to 1990, King Mahendra had ruled. Of course, he relied on a panchayati system of governance, but panchayati did not reflect either people's participation or opportunity for a democratic discussion, deliberation, etc. Some chosen members were to wield the political power. There was no parliamentary democracy also, and he tried to get the support of Indian government for the purpose of continuation of his rule. See, the Constitution of Nepal 1962 that remained in force up to 1990. King Birendra was in power in 1990. Of course, first people's movement took place demanding for a constitution which is agreeable for the people of Nepal. Constitution Recommendation Commission was constituted in 1990. See, in 1990, so we come across a occurrence of a Maoist insurgency movement in Nepal. See, Nepal kings, unlike the Bhutan kings, were not after the welfare of the people. They are not respecting the rights of people, their entitlement, their better social position, etc. No economic reform, nothing was done. But oppressive rule was the common thing that continued. People opposed that, and Maoist organizations became quite popular. There were some political parties also reflecting some of the views of some ethnic communities, and Nepal Congress was also there. Of course, Nepal Congress was one of the major political party. Marxist movement was successful in persuading to have some kind of constitutional reform, and this Constitution Recommendation Commission constituted by King Birendra was also a set of people chosen by the king, not representing the interests of people. It had no representative quality. See, in 1990 there was the tragic incident of assassination of the whole royal family. As many as 7 persons or so were killed the same night. King Birendra, then Prince Dipendra and various others got killed in that incident. There are several stories about that. In 2002, brother of King Birendra, Jyotindra, came to power. And initially he had promised the people to bring various types of reforms, ensuring human rights and protection of the interests of various ethnic communities, etc. But again, there was a forgetting of the promise. This was the general approach of almost all the Nepal kings. And he became more oppressive in his approach. And of course, the position became so intolerant that by 2007, the Nepal Bar Association leaders as well as Nepal journalists joined together, and when there was a suspension of the constitution, and there was a suspension of various rights, and there was a undeclared emergency type of situation. These people, in other words, the people's voice came to the forefront, and the political parties interfered in such circumstance, and there was a, I mean, that movement was joined by other political parties, and there we come across that 12-point program that was initiated by these bodies, and that was the beginning of the interim government. And from 2007 to 2015, we come across that gestation period in which the constitutional values got crystallized, and we come across emergence of the 2015 constitution on the basis of the work done by the Constituent Assembly 1 and Constituent Assembly 2. The first Constituent Assembly was not successful. After its dissolution, the newly elected Constituent Assembly was successful in bringing the new constitution. See, so many issues were there, and so many changes were brought from monarchical rule, there is an uncontrolled monarchical rule, to a democratic rule. There was a big change. Once and for all, monarchy was given up, and democracy is established. There is a big change. Instead of a unitary government or a unitary system, federalism was brought. Of course, there was a big debate. How many federal units should be there? Is it 6 or 7 or 8? There was some dissent about forming the 7th unit. See, the 6th one was the westernmost federal unit, and they wanted to keep this far western province intact without any kind of division, because the political parties representing from that constituent, from those areas, were thinking that they will be losing their political support in case there is a division. See, these types of partisan interests had interfered in the course of making of the constitution. Surendra Bhandari, in his very knowledgeable work, very scholarly work, discusses about the factors which deviated from strict constitutionalism, and how in the making of the constitution those challenges were responded by the constitution makers in a very tactful manner and in a very effective manner. See, from the unitary state to federal state, there is a big change. Then recognition of all the languages having equal rights, that is another change. Then protection of the interests of ethnic rights, ethnic minorities, that is another important change that was brought. Further, we come across bringing certain changes after the making of the Constitution. Of course, 2015 Constitution was enacted and it was promulgated. See, before promulgation of the 2015 Constitution, there was one Madhesh community movement, Madhesh movement in Nepal. Many of the members of Madhesh community had a direct or indirect connection with the Madhesh community in India. Lalu Prasad Yadav had gone to the extent of saying that if a Madhesh agitation in Nepal is going to be suppressed by the holders of powers, then millions of Madheshis from India will be sent and care will be taken so that the interests of Madheshis will be adequately protected. Of course, this was strongly criticized in Nepali press and Nepali writings. Prior to that, of course, how best the interests of Madhesh shall be adequately recognized and protected, about that India began to interfere. And the embassy, Indian embassy in Nepal went to the extent of communicating to the leaders of Constituent Assembly that, or the Prime Minister and others, that there shall be postponement of the proclamation of the Constitution, promulgation of the Constitution, that shall be postponed, because the interests of Madhesh shall be protected, and existing protest movement shall be adequately dealt, and if only after dealing with their interests that the Constitution shall be notified. Until that there shall not be notification of the Constitution. See, each nation is independent in making its own constitution, and it is on the basis of people's voice, or on the basis of the accepted ideologies, that a constitution is to be made. A constitution is not something to be written on the basis of dictation of a neighboring country, however big that country might be. From that angle, the interference made by the government is not a very pleasant thing, but it had its own reasons, that the interests of Madhesh were not protected, then citizenship issue was not adequately dealt, and the gender justice aspects also not properly dealt, etc. India has a open border policy with Nepal. There is no such a fenced border between India and Nepal, and the social relations between Indians and the Nepalis is so close and so intense that there are so many issues relating to citizenship. See, the development simply points out that after the commencement of the Constitution, when Madhesh movement could not be effectively dealt by, say, ignoring it, then the government thought of bringing an amendment to the 2015 Constitution. That is, within a span of 3 months from the date of commencement of the Constitution, there was an amendment, and that amendment provided for recognizing the interests of Madheshis in an indirect manner, by providing that the constituencies shall be so formed that proportionally inclusive memberships shall be ensured. In other words, the composition of the legislature shall be such that the interests of Madheshis shall be adequately protected. They did not go for any reservation for Madheshis or a creation of a separate territorial unit for Madheshis, etc. But this kind of remedy was provided. Thus, in making the constitution or in designing the constitution, the impact of a constitutionalism is quite enormous. And in bringing that amendment also, it is the social reality that interests of ethnic minorities shall be adequately protected. That operated from that angle, that is on a right direction. Now coming to the constitution of Pakistan and Bangladesh. First about Pakistan. Jinnah's presidential speech in a Constituent Assembly had reflected over some of the basic ideologies of that polity. We should work beyond the angularities of a majority and a minority. There shall be equal religious freedom, equality of status irrespective of caste, sex, religion, etc. Religion, language, etc. shall be ensured. Then a distinction in a religion, language, or ethnicity shall be regarded as irrelevant insofar as political matters are concerned. It's in matters relating to political rights, these considerations shall not operate. Then a nation should progress with the multicultural features. There shall not be theocratical state. Religion shall be regarded as a only personal matter. Thus, Pakistan was expected, according to Jinnah, as a modern, progressive, and a democratic state whose energies will be harnessed towards uplift of people. When we look to the objectives resolution, that point is given a further emphasis. And in the 1956 Constitution, from 1951 to 56, there was some period of disturbance. And on the basis of the existing 1935 legislation, they continued the rule. 1956 legislation, 1956 Constitution is the first Constitution. Then we come across the 1962 Constitution, and then we come across the 1973 Constitution. Even a 1962 Constitution was also put into abeyance or suspension because of the imposition of a martial law regime. And even 1973 Constitution was also put under abeyance, suspension, or a lot of unilateral amendments by the martial law leader. See, these factors are actually factors of deviation from the principles of constitutionalism. Whether constitutionalism had impact or whether it had a continued impact upon a constituent power throughout. From this angle, we find that there were more of deviations, and of course there was an unfortunate development, but still those constitutions had provided for a guarantee of fundamental rights, enumerated the directive principles of state policy, provided for federalism, provided for a parliamentary form of government where the cabinet is accountable to the legislature. All these principles were written in a draft form, in a written form, all those principles were there. But in actual application, there were certain difficulties. Of course, in 1959, there was a thinking that the original constitution that was put into application in 1956 cannot work. There ought to be a different model on a presidential form pattern that was initiated by Ayub Khan. Then centralized federalism was also contemplated. Unicameral legislature was also provided. This is how from 1956 constitution to 1962 constitution, we come across a kind of a deterioration from the angle of constitutionalism. If we have to consider Jinnah's articulation of the constitutional ideologies as the parameters, then we should consider that the 1962 constitution is an aberration. It is not conforming to that thing at all, because there it is not constitutionalism that influenced the constituent power. It is the individual whims and fancies of a dictator that influence the constituent power. See, when that is the consequence, how constitutionalism is not serving the interests of the society can be looked into. See, in late 1960s, there were developments. East Pakistan had some dissatisfaction with the governance in the West Pakistan, either because of ignoring of their economic interests or ignoring of their distinct cultural and linguistic interests. And of course, birth of Bangladesh took place in 1971. Meanwhile, soon after Ayub Khan's departure, when he stepped down, martial law rule was established by Yahya, another military commander. And birth of Bangladesh in 1971 is a genesis for another constitutional ideology. About that, let me discuss later. See, in 1970, again, for the purpose of framing the constitution, a new Constituent Assembly was created, and within 120 days, a draft was to be prepared. Zulfikar Ali Bhutto was in power in 1972 to 1977, and interim constitution was initiated in 1972, and there were certain issues relating to Sindhi language and other rights and other grievances. And the present constitution is one that is established in 1973. The constitution of Pakistan, 1973, is the present constitution. From 73 to present day, that constitution is continuing. See, here also we come across imposition of martial law rule, or bringing certain unilateral amendments by the dictator and so many other things. Relating to those types of amendments, the approach of the Pakistan Supreme Court was to hold that basic structure theory is applicable to some extent. Of course, there was a kind of a compromise. See, here we come across the first case where the Supreme Court considered that Constitution does not stand abrogated with the application of martial law. Muhammad Azakai case. Then there is a 2000 case where Zafar Ali Shah versus General Parvez Musharraf. There the Supreme Court was narrowing down the scope of basic structure theory, and it was almost nullifying its effect itself by saying that in those circumstances where the judicial review is excluded or some other representative bodies opportunity was not provided, it did not amount to violation of a basic structure, because a doctrine of necessity demanded that extra constitutional takeover on ground of emergency had included the power of amendment of the constitution also. But subsequently 14 judges bench overruled Musharraf case, and in Sindh High Court Bar Association versus Pakistan decided in 2009, the court viewed that no sanctity could be given to the amendment that was incorporated by an usurper, because such kind of act which results in a mutilation of the constitution or a subversion of the constitution cannot be regarded as in accordance with the basic structure of the constitution. Once again, it is the philosophy of constitutionalism that was put into service. Of course, the circumstances in which that basic structure theory was applied in Pakistan are different from the circumstances in which basic structure theory is applied in India. The issues are different, especially in India it is only relating to exclusion of a power of judicial review or say such aspects that such things are there. But there the deviations are very drastic, and even there basic structure theory was applied, but it was upheld. The amendment was upheld in some of these circumstances. There is nothing but abuse of basic structure theory itself, and not elevating the basic structure theory to the levels of constitutionalism. In Bangladesh, we come across a very strong democratic tradition initiated by Mujibur Rahman. Of course, his revolutionary speech about the independence of Bangladesh and the circumstances which need such a consideration for recognizing independence of Bangladesh. About that we come across very important developments, and now it is a part of the constitution itself. His speech is incorporated as a part of the schedule. Schedule 5, 6, 7, 2, 3 schedules are actually reflecting all such speeches. In fact, the ideologies for which Bangladesh shall form a separate nation, about which we come across that kind of references in those speeches. See, protection of interests of culture and language of Bangladesh, there is given a lot of emphasis in those speeches. See, the constitution is made in the name of the prophet and there is also adherence to, I mean a reference to various values like equality, liberty, justice, and so many things. And there is a guarantee of rights. There is also a reference to directive principles of state policy. Then Bangladesh had also suffered imposition of martial rule, suspension of a constitution, and bringing of so many constitutional amendments which subverted the essential features of the constitution. And in those circumstances when the jurisdiction of a high court over the whole of Bangladesh was removed, and high court was bifurcated. The high court division was to support the Supreme Court of Bangladesh. That was the earlier arrangement. But high court division was bifurcated, and upon the entire territory of Bangladesh, high court was not exercising jurisdiction. Because of this access to judiciary for redressing the grievances was not available, and this was a violation of Article 100, and it was bringing some change to Article 100 that it was done. And the question was whether this amendment is in accordance with the basic feature of the Constitution. Here, in Anwar Hussain Chowdhury versus Bangladesh, the Bangladesh Supreme Court Bangladesh Supreme Court declared that removal of overriding jurisdiction of a high court division by bifurcating it to several components was a violation of a basic structure, because a judicial review is excluded. And here Indian Supreme Court judgments were referred, and the argument was on the basis of partly inherent limitations as well as implicit limitation on the basis of the term amendment itself. Then we come across subsequent cases where similar approaches were adopted. When ratification of martial law proclamations were done through constitutional amendment, because of which a lot of deviations from the Constitution had taken place. There the Supreme Court viewed that that is a violation of a basic structure. Kandkar Delwar Hussain versus Italian marbles is a case where that was emphasized. Then in 2011, very important amendment was brought, by which Article 7B was introduced, and it laid down that Parliament has no power of amending the basic features of the Constitution which are included in a specific enumerated provisions. Of course, fundamental rights, directives, or other features, those cannot be amended. That type of approach can be found even in a Sri Lankan Constitution also. Under Article 85 of the Constitution, if in relation to Article 1 to Article 10, there is about the basic features of Sri Lankan polity. If any alterations are to be made, that can be done only by referendum and not by other ordinary form of constitutional amendment. See, in this way we come across the impact of constitutionalism upon a constituent power. The inferences that we can draw from this discussion is that in designing the Constitution, constitutionalism has played its influencing role in a very important manner, because the ideologies in a constitutionalism or always inspire, persuade, and even compel the makers of the Constitution to draft the Constitution on those patterns. Same considerations prevail even in amending the Constitution also. There's the overall development is towards a better situation where the Constitution's identity or its nexus with the constitutional ideologies in the form of a constitutionalism cannot be subverted through constitutional amendments. These are all developments that were possible by invoking overarching of various provisions of the Constitution, as well as connecting constitutionalism with the constituent power, constitutionalism with the democracy, and those values become quite important. With this, let me conclude. If you have questions, yes, I think there will be questions. This is a seminar meant for deliberations and discussions. I will try to answer. Yes. Yes. So first. Okay.
Hello. Do you see any future prospects of confederation, forming of a confederation in South Asia?
I don't think that the political developments are in favor of forming a confederation. Even formation of some regional organization like a SARC. Yes, formation could be done, but its effective application or its functioning is something facing a lot of difficulties about the problems you know. And each nation has its own tradition and its own problems, its own social and economic circumstances. And I don't think that confederation is something that could be thought, but there can be better implementation of SARC objectives. If that could be done, then it serves the purpose. See, the experimentation with the confederation, that was something confined to 19th century. After 19th century, we did not come across the confederations. Yes, there could be regional organization. Yes, you have a question.
Sir, is current Sri Lankan making of the constitution, is
yes,
it going to give any lessons to deal with ethnic minorities and other kinds of pluralities? Is there anything happening in that direction?
Yes, definitely. Because of lack of time, I could not deal with it. See, the development that took place in 1970s was a formation of the 1978 Constitution. There is a Jayawardene Constitution, 1978 Constitution. Until that, Bandaranaike Constitution was there. It was providing for parliamentary form of government and rights of ethnic minorities, especially Tamil, etc. It was not very specifically recognized. 1978 Constitution also provided for unitary form of government. See, when ethnic problems are something territory-based problems, it is through providing solution on the basis of territorial answers that such problems are to be resolved. But that was not done in relation to Tamilians. Even 1978 Constitution did not work on those lines. But suppression of the Tamil minorities took place, and Tamil insurgency, LTTE movement against the government, and armed conflicts between the Sri Lankan army and Tamil tigers, that resulted in a prolonged violation of public order and security of state. All such issues were there. See, ultimately it was tried to be resolved by a constitutional solution. That's by formation of specific provinces. Sri Lanka, north province of Sri Lanka, where the Tamil population will have that separate identity. See, by providing that that kind of a territorial identity for the Tamil province, that it could be done. It was not resulting in a formation of a federalism. See, 16th Amendment to the Sri Lankan Constitution provided for this kind of arrangement within the unitary system, but of course it was successful in appeasing the Tamil minority. For the Tamil language was regarded as a language equal to Sinhalese language, and for all official purposes it could also be used. Then even some administrative arrangements were also made. Thus, the constitutional ideology of equal liberty of all, that provided some kind of a solution. From that angle, constitutionalism had influenced the exercise of a constituent power. That is, the 16th Constitutional Amendment was, it gathered support from the constitutional ideologies.
Sir?
Yes, yes.
Sir, in this era, somebody else?
Yes, yes.
So in this era of globalization, where international law is gaining immense prominence, so much so that the vanishing point of jurisprudence has gained immense prominence, and it raises constitutional questions also, most importantly with respect to horizontal application of fundamental rights. So do you believe that there can be something like a principle of transnational constitutionalism, or is it just wishful thinking or a category error, in your opinion?
Transnational constitution, and see, one thing that we can find after the incorporation of various international human rights instruments is that all these constitutions, all these domestic legal systems have developed the tendency of receiving the values which are laid down in international human rights instruments. Thus, from that angle, augmenting the human rights element and component of the domestic legal systems has taken place, and globalization has that kind of positive impact. Of course, globalization of human rights or universalization of human rights, that has that kind of a positive impact. See, after the Bangalore Declaration of 1988, that initiative started. The judicial colloquium that met in Bangalore, they brought out one declaration of principles. Those principles were vital to alter the whole scenario or approach of the judiciary in relation to absorption of international human rights into the domestic system. Vishaka progeny cases, all those cases relating to application of international human rights, that arose because of that development. That is one of the features that we find in the course of globalization. But trans-constitutional, yes, this can be considered as one such a situation of a trans-constitutional development. Yes, yes, you have.
Sir, I just phrase my question in two parts. The first part is regarding the happiness which you talked about being incorporated into Bhutan. How is that different from the pursuit of happiness which is being incorporated in the American Constitution? And the second part is if whether constitutional processes can lead to undemocratic results. For example, in my perspective, I think Article 351 is probably not very democratic in nature. Could you please talk about that or comment on it?
351.
The promotion of and promulgation of the Hindi script, specifically only Hindi, and not any other regional languages.
Okay, see, about the first question, that about happiness. American Constitution nowhere says about happiness. American Declaration of War of Independence makes reference to the self-evident truths which a political community has to strive for, include right to life, liberty and pursuit of happiness. See, I think it was John Locke who considered that life, liberty and property, these are the natural rights for which the whole polity should strive for, etc. But that change was, a marginal change was made. Instead of property, the word pursuit of happiness was inserted in the Declaration of War of Independence. But in the text of American Constitution, we did not come across the word happiness. The effective way through which life and liberty or equality could be promoted, that would invariably result in happiness. About that there is no doubt. But they did not have such a distinct concept of happiness as a central principle of the Constitution. Then about Article 351 of the Constitution, it is only providing for developing Hindi as a language with the adequate resource, which could be developed on the basis of other languages, so that even people belonging to or people speaking other languages can also understand Hindi in a better manner. I don't think that any unconstitutionality will be there. It is in the original provision in the Constitution itself, and it is something in conformity with the whole ideology of bringing adequate harmony in our relations, social harmony or linguistic harmony. Yes, you have.
Good afternoon, sir. Sir, today in the morning, the Supreme Court has admitted the Article 370 petition, which is to see whether it is inviolable or not in the morning. Sir, I have a question relating to this. So you had in your speech stated that the whole idea of constitutionalism is to design or bring forth the constitution in the best manner possible. Now, sir, in the absence of a referendum or granting the state autonomy under Article 370, what is a possible or a plausible solution to the circumstance? Keeping in mind the fact that the reason why 370 existed at that point of time has drastically changed over a period of time based on the prevailing social, economic, political and cultural factors which is there today. So, sir, what would be the plausible solution as of now?
Article 370.
Yes, sir.
Jammu and
yes,
Kashmir.
sir. Giving
Special position of Kashmir.
Correct.
See, it's a fact that Kashmir became a part of India on the basis of instrument of accession, and one of the conditions in instrument of accession was to provide for such a special situation where relating to defense, communication, etc. And another thing. Yes, concerning those factors, it is the Government of India which shall have power, and relating to other matters, it's the states shall have power. And in order to give effect to that, Article 370 was enacted. But we come across a lot of dilution of that approach, because the Jammu and Kashmir Constitution provides for receiving of various presidential orders which implement the provisions of the Constitution. So there has been a say inflow of constitutional values of the nation's constitution on the Kashmir Constitution, Jammu and Kashmir Constitution, and the extent of such a movement, I mean extent of such a absorption is to such an extent that there is not much difference between the national constitution and the constitutional that is prevalent in Jammu and Kashmir. So from the angle of constitutionalism, I don't think that this kind of special position. Now, when we say that it is a special status, it is within an inverted comma we have to put it. I don't think that it's I mean it's anyway deviating from the constitutionalist ideologies. From the angle of constitutionalism, we have to see whether all those ideologies about respect for human rights, respect for a representative government, judicial review, rule of law, and all those things are made available in the concerned state or not. Yes.
In regard to the Supreme Court widening its jurisdiction in several matters regarding the diesel car ban in Delhi and levying of tax on such cars, and for even a personal matter where Sahara is put in jail for contempt without any trial, how do you see in perspective of constitutionalism and even constitution itself? One, and the second question is regarding the principle of whether the Supreme Court is upholding constitutionalism in regard to matters like even the NJSC judgment. How do you see that in that perspective? Like, because
regarding NJSC?
Yes.
See, the essential finding of the Supreme Court in NJSC judgment is that independence of a judiciary is one of the basic features of the Constitution, and in the course of appointment of judges, if the political influence in the form of presence of a law minister, etc., is likely to cause any such a adverse impact, then independence of judiciary is at a threat, and constitutionalism is at a threat because of that. That is how the link between a constituent, constitutionalism and constituent power can be seen by looking to the judgment. Then about that environmental pollution, etc., of course, we can generally say that constitutionalism is it's a brooding omnipresence, or a philosophy that that has a overwhelming reach, and it can actually reach even such a situation, and that big change that arose through public interest litigation and various other things, that is also something traceable to some of the constitutional ideologies. Yes.
Yes. First of all, allowing the Supreme Court itself to decide the validity of NJC, Isn't this against the principle of natural justice, against the rule against bias? Won't the Supreme Court be biased in deciding the NJC whether he should have the authority or not to select the judges? That's also.
Okay. No, those are all specific issues. See, I wanted to give a general overview of impact of a constitutionalism on constituent power. And the issue about the bias or principle of violation of principle of natural justice in the course of appointment of judges, etc. Those are to be dealt under the broad purview of constitutionalism. I would like to say that contextually, the judgment is fulfilling the imperatives of constitutionalism. Contextually. Of course, if you look to the logic, or if you look to the deeper, some other aspects of it, perhaps it is not possible to justify NJC judgment. You can read Professor Udayaraj's latest book, Constitutional Law, Volume 1, where he discussed that aspect in a very convincing manner. And about today's lecture, you can look to some of the literatures that I had provided, and there are so many, names of those authors and books are there. You can refer to those. And you can also refer to Oxford Handbook on Indian Constitutional Law. There is also a very good book that you can refer.
So perhaps we can invoke the doctrine of necessity that is applicable in administrative law, which is an exception to the principle of natural justice. If there is no other authority to decide, then a violation of natural justice is permissible on the doctrine of necessity. But that is an administrative law principle. I don't know its application in constitutional law context.
Can you cite any example? Which
No,
one?
no. Doctrine of necessity is not something to be accommodated in view of a basic structure doctrine. That is what Pakistan Supreme Court said in one of the cases, in a 2011 case. I think that is quite convincing.
Thank you very much, sir, for that very scholarly lecture on South Asian constitutionalism. The impact of the Indian constitutional law on these neighboring countries is a matter of study, and I wish that students would actually look at how Indian constitutional principles are being used in other jurisdictions. That there is a need for a study of why is it that the Indian constitution seems to have survived, and why constitutions around it have been struggling for so many years now. But I think it was a very useful example also in terms of the simulation that they were doing to see how principles of federalism are actually being used as conflict resolutions, how it is important to talk to persons that you might see as not deserving to be on the table, but still having to negotiate with them and having to come to consensus on important issues of governance in the larger interests of peace. So if you're actually able to look at how, and I think the best part of the lecture was to see how the impact of certain ideologies as well as certain principles at the stage of the drafting of the constitution is something that is, I think we don't pay enough attention. We're so much taken away with judicial interpretation that we don't see the impact of constitutional principles and constitutional design. And I'm very thankful to you, sir, for having enlightened us on those points. Thank you again.